My name is Vanal Enmoya. I am now posted as Member Secretary in Mizoram State Legal Services Authority. Before starting our program, I would like to introduce our VIPs. First of all, our chief guest, Honorable Mr. Justice Ujjal Bhuyan. Can you raise your hand? Our chief guest is our Executive Chairman of Mizoram State Legal Services Authority. So far I know him. He is a man of principle. He used to appear before CAT, that is Central Administrative Tribunal, during the time of his practice as an advocate. He used to represent Income Tax Department before tribunal. He was Additional Advocate General of Meghalaya government, and he was also Additional Advocate General of Assam government. He was a senior advocate under Guwahati High Court. We Mizo people, especially we Mizo community, like him very much, particularly from bench and bar. He is very friendly to us, and one of my batchmates, which presently posted as Commissioner and Secretary of Assam Judicial Department, he calls him the most gentleman amongst Guwahati High Court judges. Let God bless him to be a Supreme Court judge. He has a good chance to be a Supreme Court judge because he was born on 2nd August 1964. He has completed 8 years service. So normally it takes 10 to 12 years to become a High Court judge. So he has a good prospect. Mr. Sir Dharamjava, senior advocate, and he is also advisor to CM. He was my lecturer during the time when I went to ISO Law College. And he was also lecturer in English department in Pachuna University College before joining advocate. He is a father of MBA, Mizoram Bar Association, because he used to be president every time. Everybody knows him, so I will not comment further. Mr. Arthala, please raise your hands. He is senior most MJS officer, and he is a great one now at present. And he is the present district and session judge, ISO Judicial District, and chairman of ISO Judicial District Legal Services Authority. You come to know how much talent he has when he sits on a chair in the first session. Mrs. Helen Dongliani. Presently he is Registrar of Guwahati High Court as well as Secretary Guwahati High Court High Court Legal Services Committee. And she's also a nice person. She will sit when second session will be conducted. Mr. Vandal Suanga. Mr. Vandal Suanga, please raise your hand. We know him. He is Finance Commissioner of Government of Mizoram, and he had been as Accountant General in West Bengal as well as in Sikkim State. So he had a very good experience in the field of audit. If I'm not mistaken, he had training, a performance training course in Washington, and he was given assignment to audit UNO fund in different countries. So I'm very thankful to him because he can participate as resource person today. Mrs. Marley Van Loon. She is also a record officer of Mizoram Judicial Service. Presently, she is posted as Secretary, Law Judicial Department. She is a straightforward lady, and she has much experience, especially in the field of human trafficking. She has a good experience because she had been there in Maharashtra, in Mumbai, and she fought much during that time. And today, I'm also very thankful because we are having such a lady to be a resource person today. Miss Sylvie Zedralte. Where is she? Acha. Okay, I want to introduce you my conciliators in Lok Adalat. First of all, Dr. Raghumapoli, he is Principal of Government Mizoram Law Police. Mr. R.K. Thanga, he is a retired government servant. He is a retired IRTS. Mr. Charles Thanga, he is a retired Deputy Secretary under the Government of Mizoram. Mr. Labia Moyangende, I think you know him, he's a very popular person, and he is a social worker as well as a professional architect. So I'm very proud of them. Because of their capability, we can settle so many cases in Lok Adalat. Okay, as a chairman of this inaugural function, I welcome our chief guest of honor, resource persons, conciliators, judicial officers, and secretariat officers. Today's topic, we know, it is relationship between executive and judiciary in the state. We know that there are three pillars in Mizoram government. They are executive, legislature, executive, and judiciary. So each of them is very, very important, and those three pillars work together. The purpose of this seminar is to develop better relationship between the executive and judiciary. Though we are from judicial officers, we have right to be looked after by the government properly. We have to be looked after by the government without showing any bias or any favoritism. So we can work together. We can work together for our state. Judicial officers, as we are concerning cases, court cases, we have to do our level best for the people and for the state. And executive, as you know very well, you are under executive, you are officers under executive, so your duty is to implement laws and orders. You are duty bound to help the government and legislature people. They are bound to help the MLA's elected representatives. I hope we will will benefit something from this seminar. Thank you. Now we will have a felicitation program for our chief guest and for our guest of honor. Please come with us. Can I request our chief guest to stand here? Now, Puram Zawa, guest of honor. Now I will call upon our guest of honor to deliver a speech.
Mr. Chairman, Honorable Moya, the Secretary of Mizoram State Legal Services Authority, Mr. Justice Joel Boyan, Judge of the County High Court, as well as the Executive Chairman, MSLSA, and Chairman, SC. The learned Law Secretary, Mrs. Marley Vanku, Srimati Helen Dongliani, the Registrar of the County High Court as all bench, District Judge, Mr. R. Thanga, the MJS officers, important officials of the government of Mizoram, invitees, ladies and gentlemen. Today, I really feel honored for being invited as the guest of honor. This is the first time I am addressing the gathering as a guest of honor, such a crowd, a distinguished crowd, which I have never expected. And today, being the guest of honor, I was thinking of what to say and what would be the appropriate thing to say before the gathering. But I was just going through the newspapers of the recent past, and I was feeling that the topic of the seminar, that is relationship between executive and judiciary in the state, is something which nobody bothers about. And nobody writes about this in the newspaper. It is not something which is an issue between the government of the countries or of the people. We are thinking in terms of economic development, how to raise the GDP and all those, amongst all those issues, we are now today concentrating on a very important issue, that is the relationship between the executive and the judiciary in the state. People may think that we are just hibernating from the practical and more important issues, but that is not so. We are going to deal with very important issue today, which is very fundamental in the governance of the state. And while I was preparing the speech, I was quite at a loss as to what to say in this kind of relationship. I turned on the pages of the Constitution. There are certain things regarding the relationship between the central and the state, and few other things, the fiduciary relationship, and many other things, of course. But since the topic is regarding the relationship between the executive and the judiciary, I have the feeling that to have a relationship, there has to be a separation. Until and unless there is, or there are two separate entities, there cannot be a relationship. Prior to the separation of judiciary in the state of Mizoram, we cannot say that there was a relationship between the executive and the judiciary. So in order to have a relationship, there has to be a separation. So that's why we're thinking in terms of relationship today. So the starting point of today's topic is in the separation of judiciary from the executive. And I was just tracing the history of the separation of judiciary. In fact, I had presented this paper, Separation of Judiciary, the Problems and Prospects, way back in the year 2000, on the turn of the century. And in that, I had highlighted the fact that it was in 1978 that the first move for separation of judiciary in the state of Mizoram was taken up in the State Assembly. That was in 1978. But the manner in which it was taken up was not as what was expected, and it was not properly responded also. And thereafter, in the year 1985, there was the first order from the Guwahati High Court asking the state government as to why there should not be a separation of judiciary in the state of Mizoram also, as mandated by the Constitution of India, and as practiced by the other states, in the neighboring states and in the other states of the country. Thereafter, nothing much was done. And of course, there was a misconception in the separation of judiciary. In fact, what the officials and the important dignitaries at that time were feeling is that separation of judiciary has things to do with the application of laws, application of substantive laws, or of the procedural laws. Separation has been confused with such application of laws. It is not the application of laws, but it is the separation of power, who is controlling the judiciary. That is all. So that confusion lingered for a number of years, till when the MNF ministry woke up in the year 2005. I said woke up because the earlier ministry, whether be it a Congress ministry or PC ministry or any other ministry, they did not approach the issue in the right perspective. It was on 21/2/2005, 21/2/2005, that the Council of Ministers, under the Chief Ministership of Mr. Zoramthanga, the present Chief Minister of Mizoram, had taken up the issue regarding separation of judiciary in the state of Mizoram, and they had made a decision to that effect. Let there be separation of judiciary. That was on 21/2/2005. And subsequently, on 16/6/2005, the same was notified, and that notification, dated 16/6/2005, was taken to be the starting point of separation of judiciary in Mizoram. So, thereafter, a number of things needed to be done, and the Mizoram Judicial Service Rules was redrafted, and it was notified on 12/12/2006. So prior to that, there was a big confusion even amongst the judicial officers. And though we call them judicial officers, the High Court does not call them judicial officers, and the law does not call them judicial officers. In the true sense of the term, they were not judicial officers. And one of the members of the judicial service said, let them call me by any name, as long as we work for dispensation of justice, and as long as we get our pay, it is all right. That's what he said. Anyway, that kind of thing is now a thing of the past. We are now having a full-fledged separation of judiciary, and we are now talking about the relationship between the executive and the judiciary. So, what I have stated, that in order to have a relationship, there has to be a separation. Earlier, when there was no separation, the existence of judiciary was very minimal, and we were all under the control of the executive. Now that we are having a separate entity, we have likes and dislikes. A number of things need to be done in our relationship. And when the government is not performing its duties properly, it is the judiciary that will take the corrective measure. And when things go wrong or go astray from the legal, from the legalities, then it is the corrective measure that needs to be taken by the judiciary. And in such cases, there are few things which are to be done by the executive, but which are left undone. So in such circumstances, people who are active social workers, social activists, they'll come forward and make PIL, public interest litigation, challenging or asking the Honorable Court to make proper direction so that the state government or the executive will do its duty. So that's also known as judicial activism. And the executive, from the executive side, all those things are not very welcome. But this is something which needs to be done. The executive sometimes fails to perform its duties, sometimes overdo it, sometimes refuse to do it, and in such circumstances, the judiciary will come into the work of judiciary will come into play. And of course, that is in respect of the functioning of the High Court. But so far as the subordinate courts, the courts of district judge and below are concerned, they used to be under the control of the executive, even if such individual judges have a temperament to do things in their own way. But the expectation is, or what is in the mind of the people is that as long as the judiciary is under the control of the executive, no proper justice can never be done. So, once judiciary is separated, the people feel free and they have the understanding that if something goes wrong, they'll approach the court of law, and then they'll get justice without any harassment or without any undue influence from the executive. So now we are having that kind of separation of judiciary. But having a separation of judiciary is not enough. It has to be independent from all other forces. The judiciary has to be not only independent from the control of the executive, it has to be also free from the control of individuals, organizations, NGOs, and all other things. The control of NGO is very strong in Mizoram. Even the judiciary used to be under the control of the NGO. And now the other step that needs to be taken by the judiciary is that it has to free itself from such undue controls or undue harassments or influence from all other authorities or powers or influences. Now, it is the duty of a judge to decide the matter before him without fear or favor, that we all know. But even if it is decided without fear or favor, it still can be decided in a very illegal manner. Without fear or favor, but illegally. But that illegal part is not the concern of the separation of judiciary. Now, the role of the lawyers will come into play when illegalities are committed by the trial court, the first appellate court, or even the other courts. Now, illegality is very subjective at times. When I say a particular thing is illegal, it may be very legal for the other side. So, it is subjective at times, but it all depends on what the Honorable Court says finally. What I consider to be very illegal may be considered to be legal, right and proper by the higher courts. So when it is finally settled, and if it is not challenged by the litigants in a higher court, then that needs to be complied with. That has to be obeyed. So in that view of the matter, the judiciary is playing a very important role, and it is more like a demigod, let us say. Those who are holding the post of judges, who are functioning as such, they are dispensing justice to the parties seeking justice. So their role is very important, and they are also exercising the supreme and sovereign power of the state as such. So the executive cannot say that it is only the first court or it's only the trial court that passed this order, that it is not necessary to comply with. If I say that, even the lowest court is exercising the same power, the sovereign power which is entrusted upon the judiciary. So until unless that is set aside or quashed by the appellate court in appeal or by a court in such other proceedings, then be it ever solo, or even if it is passed by the court of first instance, it has the same effect in the administration of the state. Since today we are having a gathering of the officials of high importance, we need to give more importance to the directions, the orders of the court at every stage. And today I'm very happy that we have the presence of Honorable Judge Mr. Ujal Guyan, who is, as stated by the chairman, very able and who has shown his distinction in different fields. Now, not only to hold the courts, but also to enlighten us in this aspect. He could spare his time to come over under the rainy season, risking all his life and all, and I hope nothing will happen to him. He will be given all necessary guidance by the Almighty God. And I am on seeing the resource person, Mr. Banal Suanga, Finance Commissioner and Secretary of the Government of Mizoram. I was a little surprised that he is presenting a paper, Expectation of the Executive upon Judiciary in the Administration of Justice. He being a finance expert, INAS, I believe that he will be more homely with other things. But when I had a brief talk with him, he said he has some few experience. That's why he has maybe accepted the invitation. And I am really happy to have that kind of officer today in our midst. Of course, Mrs. Marley Van Oom, she is expected and she is in the line. I don't know whether she has a good preparation or not, that's a different matter. She is supposed to deal with the role and responsibilities of Executive for development of judiciary. And when I talked to Mr. Manoj Chuanga, I said to him, it should be the other way around. His topic is expectation of the executive upon judiciary. It should be the expectation of the judiciary upon the executive. What is expected by the judiciary from the executive is that in terms of figures. In terms of figures. That is what is always expected by the judiciary from the executive. Apart from figures, if they interfere with the other things, that will not be very liked by the judiciary. But when they are coming with more figures, it will be very welcome. Anyway, he is presenting a paper the other way around. I wish to listen to what he is going to present. Anyway, today I'm really happy that we have this kind of session, and I wish all the resource persons grand success, and I wish everyone present here today at least an inch of progress with all the topics that will be discussed today. Thank you.
Thank you, Ramzawa, guest of order.
This is a compilation of 10 schemes of National Legal Services Authority, translated from English to Mizo language.
this compilation of 10 schemes of the National Legal Services Authority. It was translated by judicial officers and advocates. And finally, it was edited in visual by Mr. C. Chonsoi. Please stand. And especially in visual language, he calls himself as super specialist. That is why when you read this compilation of schemes, you come to know how much talent Mr. Sridhar Senten is having. Okay, now we'll call upon our honorable chief guest to deliver a speech, and we are giving him free time. Free time in the sense that he can make a short speech, or if it is lengthy also, let us be patient. Executive and Judiciary. Mr. Marlon Moya, at the outset, was kind enough, he spoke kindly of me. I do not know, these are not in anybody's hands. But Moya is a good officer, he is a good man. Sometimes he rings me up in the morning, he says, Lordship, I have come from Saiha, I have organized this program, I am tired. I tell him, don't be tired. Sometimes he calls me in the evening, Lordship, I am frustrated. So I tell him, don't be frustrated. The next day morning, Mr. Moya calls me, this PLV, this Integrated Council, they are not doing their work properly. I am very angry. So I tell him, don't be angry. So he's a good man, and he's a very good hard worker. And you can all see the difference. In fact, the journey started with our law secretary. She was the member secretary at that point of time. Then Mr. Gulte came, then Denga came, and the good work is being continued by Mr. Gulte. We have done, it's not like patting ourselves on the back, but the things that we are doing is quite visible. And this program is also an extension of what we are doing. Mr. Nandan Zova is a good friend. He was apprehensive about my well-being. I assure him that nothing's going to be, I don't foresee any threat to my life. I'm all well. And coming to Mizoram, it's a pleasure. It's beautiful weather out here. And the song sung, of course, I didn't understand what he was singing, but it gelled so well with the ambience. I wish it could have been in the evening. We could have enjoyed it more. This topic, relationship between executive and judiciary in the state. See, India is a republic, a constitutional republic.
and it's governed by the rule of law. I'll be very brief. Mr. Moya was saying you take your time. I don't want to take time. It's 11:04. I'll finish it up by 11. Okay. Our constitution is the supreme law. And all laws and all actions, whether it be judicial, legislative, or executive, must conform to the grand norm. That's the constitution. It's the basic law. And Supreme Court is the custodian of the Constitution. As a modern nation state, those who are students of political science, they will know how the modern state has developed, evolved. And there are three organs of the state: the legislature, the executive, and the judiciary, with traditional roles assigned to each of the organs of the state. They have defined spheres within which they are supreme. Traditional concept: legislature legislates, makes laws. Executive executes the laws and administers the state. And judiciary interprets the law and also adjudicate disputes. So this role of the judiciary. Now, when we talk of the Indian context, and then we come to the state of Mizoram, when the framers of the Constitution visualized the situation, they visualized judiciary more as an adjudicating forum, a forum to adjudicate disputes between parties, primarily private disputes. Even no less than a person like Dr. Ambedkar, he had visualized that the judiciary will remain within the confines of the adjudicating limit. He did not visualize the extent of Part 3 of the Constitution of India, that is fundamental rights, and the judicial remedy, and thought that judiciary will primarily confine itself to its traditional role of being an adjudicatory body. Now, over a period of time, those who are students of law or legal history, they will know we have the Constitution. Part 3 is the fundamental rights, Part 4 is the directive principles of state policy. Immediately after India became independent, Mr. A.K. Gopalan, he was a communist leader from Kerala. He was arrested under the preventive detention law. Then it was this combined state of Madras under the preventive detention law. So he challenged his detention. Madras High Court turned down his challenge, rejected his challenge. He said that you can't detain me just like that. The detention has to be, it's a preventive detention, it has to conform to the basic principles of nature and justice. The matter went to the Supreme Court, and that's a famous case of A.K. Gopalan versus Indian of India. Supreme Court in 1950, it's a judgment by 4:1, upheld the detention. Supreme Court read down Article 21. Article 21 is just 2 lines. No person shall be deprived of his life and liberty without the due process of law. Supreme Court said that as long as there is a law in place, secondly, the administrative action conforms to that law, there's no need to look beyond. So therefore, his detention was upheld. The argument that was advanced before the Supreme Court was that the due process that Article 21 speaks of is a process of fairness, and this due process, this principles of nature and justice is inbuilt in the due process. I think we were just an independent nation in 1950, Supreme Court also, this was early days of the Supreme Court. So perhaps this was thinking 2 steps ahead. Only Justice Fazal Ali said that no, our laws cannot be just like that. It has to be not only just, it has to be just and fair too. So he read down principles of natural justice into the process of due process of law. He brought in the American due process in Article 21. But the overall majority judgment was that as long as there is a law, and secondly, the action conforms to that law, it is all right. The law need not go into vague concept of natural justice read into the law. This was in 1950. There are many judgments in between. Ultimately, in 1977, emergency was declared in India. We all know 8 emergency was lifted and the government came. Maneka Gandhi's passport, she was impounded. She wanted to travel abroad. She was the daughter-in-law of the then Prime Minister, Mrs. Gandhi. Her passport was impounded. She challenged it in the Supreme Court, saying, I have a right, fundamental right to travel abroad. And you cannot, without assigning any reasons, you cannot simply impound my passport. The Supreme Court, this time in a constitution bench, 5 judges bench, overruled A.K. Gupta. This time Supreme Court said, it took almost 30 years, 1950, this came in 1978, that there must not only be a law, that law has to be just, fair, and principles of nature and justice has to be read into that law. So it's a recognition of the due process doctrine by the Supreme Court. It came in 1978. Since then, the law has developed. I'm saying this because the expansion of the courts increased thereafter many folds, which was not foreseen by our forefathers, the framers of the Indian Constitution. They never thought that there would be so much of expansion of judicial reach. Now, this was never visualized. As a result, some are saying that there is a distortion in this delicate balance of power that we have. Executive, legislature, executive and judiciary. Because of this power of judicial review, excessive use of the power of judicial review, there is a slight imbalance in the delicate balance of power. This is leading to a lot of friction. Some people again say that for a working democracy, a little bit of friction is good for health of the democracy. Judiciary, executive and legislature need not necessarily be pally. There has to be a little bit of friction. This is good for the health of democracy. That's one school of thought. Now, what has happened is this. Because of this expansive interpretation given by the Supreme Court, natural justice has been given a wide role. It is no longer confined to quasi-judicial proceedings. Earlier, the view was that only in quasi-judicial proceedings, principles of natural justice used to be followed, or should be followed. But the judgment of the A.K. Kripak came that the thin distinguishing line between an administrative action and a quasi-judicial action was obliterated. And even in administrative decision-making, principles of natural justice were read into. An administrative decision which affects the civil rights of a person or entails adverse civil consequences, it was held that principles of natural justice has to be followed. So there is a great increase in or expansion of the principles of natural justice. This is one thing. And side by side, what we have noticed is that the relaxation of the rule of standing. The normal traditional rule is that only that person who has suffered a legal injury can come into court. That's the basic fundamental principle. Now, because of this development of this process of judicial review of administrative action, there has been, on the one hand, there is an expansion of the principles of natural justice and Article 21, life, liberty. These have been given an expansive meaning. At the same time, there has been a relaxation of the strict rules of standing. This has given rise to what is called public interest litigation in India. Yeah. Earlier, only suppose I had suffered an injury, legal injury, I could come to the court. Now, there is a group of people, they are poverty stricken, they cannot express themselves. Somebody can take up, an NGO can take up, or a leading social activist can take up their plea on their cudgels on their behalf and approach a court of law to seek remedy. So this is how this PIL thing has evolved. Now, I was talking about judicial review of administrative action. This is, judicial review is a recognized doctrine of all Anglo-Saxon, all countries having Anglo-Saxon jurisprudence. It means that the higher judiciary has got that power to review administrative action. Administrative action or administrative decision, review of administrative decision does not mean looking into that decision on merit. It means the court will only see whether, while arriving at that decision, the decision-making process was fair. The decision-making process did not suffer from any arbitrariness. The decision-making process did not suffer from any irrationality. It did not suffer from violation of the principles of natural justice, which includes bias, so on and so forth. Only on these limited principles, the higher judiciary reviews administrative decision. This power is conferred on the higher judiciary in all countries, all jurisdictions which follow Anglo-Saxon jurisprudence. In India, Article 32 empowers the Supreme Court, Article 226, 227 empowers the High Court, there is provision of special leave petition, so on and so forth. But these are all the higher judiciary. So therefore, now doing this, the court has also, particularly the Supreme Court, has developed a concept called continuing mandamus. We all know there are certain writs which the higher courts issue. One writ which is issued is a writ of mandamus. A public authority is entrusted to do a public duty. Suppose it is brought, it is alleged or it is contended that that public authority has not discharged its public duty, assigned, entrusted or mandated under the law, then a writ of mandamus can be issued by the higher court. A quasi-judicial authority, if it does not follow basic principles of law, or if there is error apparent on the face of the record, this can be corrected by the superior court by issuing a writ of certiorari. These are general principles. Now what has, because of this PIL concept, relaxation of this rule of standing, enlargement of the scope of natural justice, what has happened is that Supreme Court had taken due note of the depletion of the forest cover in the Northeast. And this gave rise to the famous case of Godavari in 1995, and that case is still continuing. So there, Supreme Court is monitoring. It has issued certain guidelines and it is monitoring, particularly the forest department, how it is working, and this case is continuing. So therefore, it has given rise to a new concept called continuing mandamus. That's how the courts monitor. Now, of course, so therefore, it is the duty which is assigned to the courts to judicially review administrative decision. It is not that judiciary does not like the executive, or a particular judge does not like a particular executive officer, therefore he is weak. It's not like that. It is power vested in the judiciary to review administrative decision making, and in exercise of that power it is. But at the same time, there has to be a word of caution here. The judiciary must also exercise restraint and show due deference to the administration. This has been reiterated time and again by the Supreme Court, particularly in matters relating to policy, finance, tenders, because any unwarranted interference in a tender process may lead to escalation of price. And therefore, it is essential. Of course, you are to see that the law is followed, there is no arbitrariness. Then certain principles are there within which the court must exercise. But again, while exercising their powers, there has to be a restraint. Power and restraint, they go hand in hand. It can't be that I only exercise powers without any responsibilities or without any response. So therefore, the separation of powers, that the three organs of the state, this is one of the fundamental principles of our republic, and this is in fact recognized by the Constitution of India in Article 50 of the Constitution, which forms part of the directive principles. And this Article 50 says that the state shall take steps to separate the judiciary from the executive in the public service of the state. This is the mandate of Article 50. In fact, in one judgment, Union of India versus Sankar Chand, 77, Supreme Court observed that this is the conscience of the Constitution. This article is the conscience of the Constitution. Why it has to be separate? You may ask the question, why it has to be separate? It has to be separate because it has to look fair. It has to, a judgment or a judge not only has to be fair, but he must appear to be fair. And this fairness, the appearance of fairness, has to be from the perspective of the litigant who is before the court. We may still be fair, but it is the perspective of the litigant which matters. An executive officer who decides a case of death penalty and imposes a sentence of death penalty, certainly there will be questions. Not long ago, this was the position in Mizoram, this was the position in Nagaland, this was the position in Meghalaya, large parts, even in Assam also, two hill districts, Karbi Anglong and Dima Hasao, the judiciary have been separated from the executive only very recently, only last year. So, of course, these areas, for historical reasons, were secluded, in fact were treated as secluded areas, and therefore the normal, the British administration, the rules of the British administration were not applied, giving due deference to the customary practices prevalent in this. But as we progress, as we move ahead, as we see the Constitution, all of us will acknowledge this fact that many of the practices which we follow, though traditional, though may not be in tune with the modern thinking, today's thinking, or the constitutional philosophy. So gradually, it has to be separated. It is a constitutional principle. In fact, Supreme Court has held that separation of judiciary is intrinsically linked with independence of judiciary, which again is a basic structure of the Constitution of India. Keshavananda Bharati's case, you all know the concept of basic structure doctrine was evolved, and that was developed later on. Even in the latest National Judicial this committee, NJAC case, where there was a law minister was made a member, of the expanded collegium, this was challenged. Supreme Court in a very long judgment has held that independence of judiciary is non-negotiable. It is a part of the basic structure of the Constitution, and therefore any act or any action which infringes upon this basic structure will be unconstitutional. It was one of these principles on the basis of which this NGAC Act was struck down by the Supreme Court. So, as Mr. Lalam Jomba has stated, in Mizoram, I think from 1986, the judiciary has been separated. Prior to that, there were a lot of teething problems. 2006, yes. Prior to that, there were a lot of teething problems. Now it is separate, completely separate. And but at the same time, our judicial officers must also, that's what I'm saying, that this is one part of the organ of the state. We must show due deference to the other organs of the state. Together, we are the whole. Judiciary, executive, legislature, together we form the state. One organ cannot upstage the other. So, it's a question of mutual respect and the space for each other. So, sometimes when the judiciary, say, passes an order of, say, land acquisition matters are quite common here, or say interferes with the settlement of tender, one should not think that this is an interference or intrusion by the judiciary into the domain of the executive. It is the power which is given by the Constitution, which power the judiciary has exercised. Likewise, while doing so, the judiciary must also show due deference to the views of the executive. The legislature doesn't come in here. Legislative action is basically with the higher judiciary. As things are unfolding in Karnataka, as you may be following, this is that's where legislature or judiciary comes in. Now, see, ultimately, and here I have noticed, I've been coming here 2011, I was the station judge here, and I have noticed that the administration in Mizoram is very receptive to this idea of separation of judiciary. It's a very welcome thing, and I must compliment all the officials who are at the helm of affairs. This is not so in many other states. We are finding it, I would like to take names. We are finding it very difficult in a couple of states which are under the Guwahati High Court, but jurisdiction of Guwahati High Court, not so in Mizoram. And it's a wonderful thing. And as a result, what we are noticing is that many good people, in fact, I was associated with many of the selection process. Many good people are coming here, and I can say the new judges who are joining the Mizoram Judicial Service, they're very good. In fact, they can walk into any of the judicial service of the country. They're that good. So we have a good, bright prospect, and I'm sure this balance of power, this is very delicate, and it is the duty of everybody to ensure that this apple cart is not turned topsy-turvy. It is very essential for the state, for the governance of the state, to maintain this equilibrium. And of course, sometimes one organ may go a little bit here and there. Then we have the system in place to put things back in control. Even if there's a trial court order is there, when we say judiciary, we don't only mean the High Court. We have the under 235, we have the district courts. We have a three-tier system of judiciary here: district court, trial courts, High Court, Supreme Court. So, therefore, even if there is, if you feel that in order of the trial court is not in accordance with law, remedy is always available by filing appeal. Now, there's one thing which I must mention. For example, a matter is pending in the court. This matter is pending in the court. Court is deciding that matter. It is essential, therefore, that the administration doesn't start a parallel proceeding on the same subject matter and arrive at a decision, thereby rendering the court process null and void, infructuous. This, in fact, may amount to contempt of court. Now, again, contempt of court is a big issue. Contempt of court is a power given to the higher judiciary under Article 215 and the contempt laws only to ensure that this delicate balance of power is maintained. It is not power given to an individual officer, individual judge, or individual judicial officer to ensure his or her supremacy. It's not that. It is only meant to ensure that there must be deliberate and willful disobedience or intentional non-compliance to an order of the court. This is essential because otherwise, if court orders are not complied with, then the court becomes functionless, toothless, and that will be a devastating blow to the rule of law, which again is the basic structure of the Constitution. So, our resource persons are there. I'm sure they will highlight, they will discuss upon various things. Now, after separation, there are a lot of things. Infrastructure is there, where both the executive and the judiciary has to work together to build up proper infrastructure. So I'm sure our resource persons will dwell on this aspect. Ultimately, the objective of all the three organs combined together is good governance. We are here to provide good governance to the citizens. And good governance, one of the basic attributes of good governance is the sense of justice. Without justice, and justice can mean many things. For a sportsman who thinks he's competent enough to be in the playing 11 and is not included, he harbors a sense of injustice. It need not be only in a court of law. He may come before an administrative officer to seek a relief. He is not given. So therefore, when we talk about the three organs of the state, we all are there to serve the people as organs of the state to ensure that our people, our citizens, get what they deserve. They deserve a good life, and for that we have good governance. And good governance and justice, they go hand in hand. I don't want to prolong my deliberation. We have the whole day today, and I'm sure we'll have some interactive session as well. So I thank the organizers for organizing this very relevant and contemporary topic. I'm sorry I have exceeded my time limit, and I wish all of you all the best. Thank you.
Thank you, Madam. Your speech is also very encouraging, and we really appreciate your speech. Now we'll have tea and snacks. You have tea and snacks.
The first technical session will commence now. Kindly gather in. Pola lau teka handu komila chane. Let us begin with the first technical session. This is on topic is on expectation of the executive upon the judiciary in the administration of justice. I am R. Thanga, presently the District and Session Judge, Aizawl Judicial District, and also the Chairman of the Aizawl Judicial District of the Legal Services Authority. Honorable Mr. Justice Sujal Bhuya, Honorable Mr. C. Laram Zawa, our resource person, Mr. Vanlal Chuanga, INAS, also the Finance Commissioner. Probably the organizers of this session have a particular mind calling on the Finance Commissioner. As we already heard in the earlier sessions, there is this welcome speech and felicitation. I think this has already been done by our chairman earlier. So I don't think I have to carry on with this. We have the three organs of a democratic government. We have heard the legislative, the executive, and the judiciary, who all play our own parts. Now, I think it is the part of the executive, especially the Finance Commissioner, who has to play his part today. We'll call upon him. I do not have to elaborate. He's a learned man in his own field. He's a senior officer of the government. We'll call upon him to speak on the subject of expectation of the executive from the judiciary. I think it should have been the way around, the expectation of the judiciary from the executive. Anyway, he, being a man of finance, we have a lot of finance problems in the judiciary. The judiciary has recently been separated from the executive in the state of Mizoram recently. There are still a lot of works that have to be done. We still need to establish a very healthy relationship between the executive, the judiciary, and the legislative. We have the legislative now with us, Mr. Laram Zawa. And in this context, I would like to invite Mr. Vanlal Chuanga, INAS, Finance Commissioner, Government of Mizoram. Take the tax, please.
Chairman, Wartama MGS, respected Chief Guest, Honorable Mr. Justice Janpu, Guest of Honor, Usi Laram Zawa, our distinguished invitees, legal experts, and my friends from other departments of the state government. All of us are quite surprised why I have been invited. I also was very surprised when they had invited me. This is not my topic at all. That's what I was telling them. In the beginning, they said that it would be assigned 1 hour 15 minutes. When I said that that's too long, then they had cut it down to 1 hour. Unfortunately, now my time already was over. So even if I take very less time, then we'll have a better time for interactive session, where we can raise a lot of questions and then there are lots of other experts. It is indeed a privilege to be invited, but I cannot say that it is a pleasure to be invited as a speaker. Anyway, I did not want to run away, and then why I believe that I was invited was that when the guest of honor had also mentioned, and the chairman also just now had mentioned, it should be the other way around. Because from the High Court and from the Law and Judicial Department and from Lokayakta, they kept on coming to me for more fun. So I think that was the only reason why I was invited. And in the beginning, had I known that it would be a workshop, in all likelihood, I would not have accepted. Only when I saw the full program, I came to know that it was a workshop. I thought it was something like a sensitization seminar or something like a legal awareness campaign. Because there's a difference. In a workshop, I have to come prepared with some case studies and then engage the participants. We'll have a discussion, even if it is not an actual case, but it should be a very similar case of the actual case. Then we would discuss, come up with something constructive. So that is usually the way I understand when it is a workshop. It does not matter, let it be a workshop or let it be a seminar, so that we can have a better understanding. When I was invited, they told me that it does not matter if I speak in Mizo, because most of the targeted audience will be Mizo, and then for the better understanding. Because here our knowledge of legal matters varied. For some, they would be an expert, but for many others, they would not be knowing about that separation of powers, which was explained in detail by our chief guest and various other speakers. Mizo, I'll say a lot of things in Mizo and then I'll try to mix it up. Hey, mina so better or junior, so to the Ziampo too. Cafe to Glova. Amaro to Engagamo can experience them data in Hetian Hanshare. We let me don't get on what I'm fighting there. Alone in Takin, Amundungate, Cananova. A big takin experience law Tumza Ahizuan Orissa online Kanani Bika Tumber to Tilmanika to the Trump again the executive in the judiciary can expect the experience of training I'll narrate more on my experience while I was in Orissa because that was the time when I had first actual contact with the judiciary from the executive point of view. I was in the state police service before for a short period, but in the state police we were mostly dealing with the child section, how to judge the criminal in this section of the IPC, etc. But nothing much in details. To an executive level, heavy judiciary to some, Kakatukan, so you might be carrying over 3 organs. Legislative, executive, judiciary, and I'm so from executive, legislative, dancing to parliament, Kandaya, Kulok Sabah, Raja Sabah, legislative assembly Kandaya. The Siama coming auto executive to Kandida. So one come executive, Taka, and reviewer, and Shilfiato Katsu, judiciary, and Imayatika, Amizotomin. All songs of in and Soitaya. And so if we see a lot of people in interactive session, a legal expert and Tama, and on Soi, via Azel to a night. Nimit Piakani, Hedia session, and the workshop seminar, and they don't ta chuanin thil dang karil ro ru ta mami home minister kan taxation minister ni pucha mai ka zuya kan taxation mun tur ta kan na kade kan en zo ton do khan ni police lan pang home chan ko ba khan ni na to ko ko jail kan to jail a khan district jail mami kan ba to jail ta ga lo to wa min pa le mi sia ka pakhat be ka convict ni ka sia ba ka chu UTP under trial prisoner so khan ni ta ta chuan in engeng ha sang ta po khan lo so jail authority te in ata mo te pon an ta na na sha me me ma in thiam na te tha to lo a te sia te in an in chun fak sa sia te engem mo kha an soi ni ta kha a shem ani thiam lo chan ma chu criminal tak tak ko kha an la ni sia chu lo ba a le la ma chuan kha ta khan ka ri lo kha ra ro ma ani kha chuan an ha sa ta kha executive fa an om na mun infrastructure a that the na te khan lo thlen ta a le la ma te ka te ka ngai to na chu na mon thlen le te zela ni expectation of the judiciary actual he tilam panga a magistrate lam pang te mo a judge lam pang te mo a judiciary lam pang kha ni jail ke va thawin khati ngan har sat na kha an va en tin executive ne la he an ta te an ta na te a shau be be tu na ta ki chuan chu ti an thiam lu chang pom la ni chungong lo wa la try to make them ya anom na te hi te min siam chan sak tiu tin ten man la ve mo ti ka ka ro kha chuan lo ma a chan chu an mani na la prosecute tu he dilai an chu chang la ngai tu kha an dia a ri po le thiam lo ban chang chan ma ka chu sheu man tu ra a le ma chuan in shem na kha an ko me ni tin dik lo ta ka ta te no pe kha chuan a shem na kha da bol ina ma dia ni ka ka ro chuan no ma executive lam panga thil no thlen ta ka chuan ya judiciary lam atang hian in enge an ti ve an nei ro ti ka ka lo khara lo ne mai mai ni an ta na chu a shau ko mai kha ka han sei ve do kan topic ni a hian ni ti na khana shil fia ga ya tin so ko separation of evil an chu powers te ein balance ngai zia te check and balance anga ya tin kati ma katu thade na soi ko mai to logina administration of justice there here in inga tinge mi here in justice then why do they seek justice in the court of law who are the people who had gone the aggrieved person those who are happy and who are satisfied they do not go to the court only those who are dissatisfied they go to the court who are those people detaila and why firstly, due to the action of the executive, there are some people, let's say non-government people who has gone to the court to seek justice. He to land compensation case and one to executive action of anga. Heta bidang sarkar mi ni hero po kha lumoy lawin kota kal bidani digna duin kha secondly, those due to the action of the government executive, the government employees themselves, they go to the court. Pay upgradation finance pay upgradation transfer and posting case yang kali pay level case ang pay chu karan tong ko ba 6 pay no pay ka chu ani po pa pay chu kha plum mo pay chu na ko ma zaliana and 616 others ita kanya lumoy lo kana tame man there are great people zaliana and 616 others it did not stop there the court had ruled in their favor and then there are many more who have gone in the same type of case. So those government employees were also dissatisfied with the action of the executive. So they have gone and seek justice from the court of law. Then, let's say another person, thirdly, is the other way around. Is the government executive who has gone to the court for justice. When some of the government employees had committed fraud or some criminal cases, they are prosecuted, and then justice, it has been submitted to the court of law for justice. Kakatiang ang at isang trangin court hankal ho katu ananta asiyatani. Takanin, what is expected from the judiciary to the executive? Having been prosecuted, the government employer, so in CRPC 197, where Section 19, IPC by prosecution sanction order. He paid an eye. This is where I had an experience regarding the prosecution sanction order under Section 19 PCO. Let me explain a bit of my position there in Puri. Puri had 2000, I was transferred there in 2001. In the month of November, I went there and joined on 5th November. And then they were telling me that some divisional accountants were having a vigilance case, and then they were waiting for prosecution sanction order. I did not know what the ABC of prosecution sanction order, and then I did not know what was waiting for me in store. Divisional accountant he can say no. Mizoram upon can detail accounts and treasury lawyer, so I'll explain it later in English because I had to go to the court to explain the status. Mi zatung chuang anoma orisa kon puri akon in DAG works account le works audit works people what accounts number le works audit what independent charge anoma DAG mo senior DAG na ko ko AG office ta ka chu bugare so ra pa thunga min transfer ma pe chuan office kan nei po ka shelo bugare so ra office ko ka shia Manipura min transfer to machine ko online choice pani chene ante Manipura mi kha agar tala transfer to lo fa khan CG office time min phone choice pani chene Shillong ma chuan yom thei lo wa he DAG ni ka sa go na to again you have two choice one either agar tala or puri agar office kan nei agar tala ka kal pe lo khan Puri kakak lagi kat dia, betul? Kasih ni ada ni, cuma ni transfer tak kat kata, cuma prosecution sanction, vigilance case kan orang yang buat kop maya. Jadi orang accountant kan ada satu cuma kan association bukan cakap prosecution sanction orang pelu tu kan ni orang orang benasa. Kati yang orang boleh lah kan ni kasus nama, pahami kan ni decision lah nama lawa, kan lalu tikul lah tu, bayi transfer cuma khana kata vigilance lampangin minum nor na sato ko ta kan thelu to don sarkar na to prosecution sanction order delwin ko ka prosecute silo ano ti min no tani kana takale ato pa chumani kana ne na chu was there keni executive chu ani prosecution sanction order kan don chu was there ni prima facie case tin chu lo again, if fail in case and see if I can do the book and the Tommy, a little much can start the book and chan the Tower. Mase at all what's there's no way out we have to deal prosecution sanction order. At Sansu executive Kionja irrigation division pioneer, executive engineer AE division accountant case and see corruption case. Takani Executive engineer le katu state government in appointing authority and the accounting prosecution sanction order and pe maya ke ni kha chu the accountant in ala unor vel den khani kan pe talo lo kha ni ya chuan ke kha chu kan pe ato pa cha kan pe ta loina khan siam lo na ma ke ti ko me principal ji chu ning tin siam lo wa ta te to bin ka soi ve kan chan bi chu ma ro chu tan pe chu I had granted the prosecution sanction order in the month of December 2001. That is where the executive expect the judiciary speedy disposal of cases. From Puri, I was transferred out of Puri in the month of August 2005. So I remained there for nearly 5 years to Hyderabad. I remained there for a short period. Then I came here to Aizawl. I looked after this construction of AG office right from the beginning. I remained here for nearly 7 years. Then after that to Calcutta, then to Gangtok. I came back here on deputation to the state government in 2017. Then last year, I had been contacted from Kyoja court. Then they had threatened me with arrest warrant and contempt of court because of the prosecution sanction order which I had granted in 2001 December. Very long case, I also had forgotten. Then finally I went there in the month of June last year to Kyoja, which was very far from Bhubaneswar. That was my first time in Kyoja. I had to go there and then testify in the court, district assessor court. It was quite uncomfortable, but even though I tried my best not to show that I was quite uncomfortable. But it does not make sense. After so many years threatening with the type of contempt of court and then arrest, I was there in Puri for nearly 5 years. Nothing was done. So that was the case. So from the executive, one of the expectation is speedy disposal of case. I looked after divisional accountant, so that's one. Another expectation was on the positive side, when many times due to the action of the executive, the court had interfered and then they had passed the ruling in favor of the aggrieved person. Sometimes, or most of the times, let's say, the executive are not capable of handling legal matters. That's why we have to rely on the legal practitioners in almost all the cases. Even then, in almost all our cases, we are on the losing side in the court of law. Most of the judgment are against the action of the executive. We have to be careful in our action, and then, I don't know, later on, when it was reviewed in the court of law, then we should not be on the losing side, or when we are fighting for the case, I think we should also try our best. That is one side. When I say that we have to be very careful with our action, at the same time, our expectation of the judiciary is that they should also take every angle into consideration. If they do not understand, try to understand what is the case about. I was talking about the divisional accountant. They are a very unique case, unique cadre. In the case of Mizoram, they are under the complete control of government of Mizoram. But in the case of divisional accountants, where accountant general is the administrative head, their position is different. From the British legacy, they are appointed by the accountant general. Their cadre administration is with the accountant general, but their salary is borne by the state government, and their pension is borne by the central government. You can see the complexity. There are certain other divisional accountants who are also recruited through PWD clerks. Those public works clerks, when they are inducted into the divisional accountant, their salary is borne by the state government, even their pension also is borne by the state government. So you can see the complexity. It looks very simple, but when it actually comes to the technical interpretation, it can be quite complex. There was a case I had when I was in Puri on the transfer of one senior DO from Good Irrigation Division to Bhubaneswar. He was suffering from cancer. Because of that, I had some sympathy. Good was very far off. So I transferred him to Bhubaneswar during the annual change. But unfortunately, he said that the division is too small. I did not want to join. In the meantime, since he was suffering from cancer, he passed away, unfortunately. And without informing the office, previously he had gone to Apollo at Chennai for all his medical treatment. After he passed away, all his medical reimbursement claim had been submitted to me. So then I had passed on to, I asked the state government, since the salary is borne by the state government, you also provide some fund for this medical reimbursement case because he had already passed away. And then medical anyway is under the salary head, so you please provide this. Then the state government was quite reluctant to give. They did not do anything. Finally, the family had gone to the court. That was where I was called to explain in Katak, CAT, Central Administrative Tribunal, Katak bench. Then he was asking me, when you say administrative control, what do you mean by that? Then I said that appointment, then transfer and posting, all the discipline proceedings case, then sanctioning the pension, etc., etc. Then even removal. Then, but their salary is borne by the state government. The judge could not understand. He failed to understand. He said that if I employ someone and then if I give his salary, definitely I would like him to be under my complete control. How can it happen? It's low can pay one. Can two more than Octagania. Mase, hey, nothing at this one in British line, division accountant of division and posta. So an executive engineer then was a Susan and do one till for case till cheat. Our Luna card independence and the Natulin, and who I card in AG controller card in that. Come independence of that card there. Come as a carnage. Because so if after a long time, then he said that okay, I understand. What is the reason for that? They have to maintain their independence without being completely subservient to the executive engineer. He passed the number. 60,000 should be immediately provided by the state government to DAG Puri and to be disbursed to the family. State government kan king le don ne na to kileng ba kan mulai service azum du lo tin na kalon kon medical treatment ti don kon ti lo re kan kan kon ka sosan ta nge ni lo ka chu ka shet talwa kan lom pa ka chu kami pandia ka expectation on tan chon ka so itu we from my own experience speedy disposal of case to consider all angles and see that a fair justice, kaka and judgment kan executive pangatan low basic. Not always it should be against the executive. Kaka tu kan atur lah macam kacang dekat wi ketika di sini apa in zone Kaka answer the top which only our to think of Captain Sweden, the just the department structuring local data to one. Only the important to some he can sway them. They are going more young. Just explain the one thing about this only important. The Nipumas are in Delhi High Court calling. All India portal are here heavy X Zong Song led. All the relating regulations should be uploaded there, and it should be in a readable format there. So to 2017, no, the ICT ka November sa kala khanin hemi thili achunga khana tlani up lo ti atel va lu khanin ka ria eng ma ICT ne nei zong na ni lo a chan so ICT state government ne ta tin aport ka NIC e central ho moi mi in an siam khan sia ICT ne nei zong na kha ong lo ma se to pa cho nên alo pe dai pe lo di to ga se na wa ka ni dai lo tu ti thei cho nên lo boi pi men le ni ti ta ka chon ka hai ko chuk chuk ka ti ha ni ko nge ti ta cho nên kan chen muang le thil trong cái nó tụ ra nghe min India trong mà đã zong actor kami collecting regulation ho zong le gazette notification zong de hun kata or kala khani hun na tu khani mase a buai tha ka be to readable format anti kharta enga mobi ka trong por ki trong po han search de ka scan ka ti upload ka athi lo akak between han type PDF han convert to readable format da to upload to khani Mizoram kan buai na chu han soi so da zerila 2008 printing and stationery how we kim nei thakar ni ta record 2008 da trong chuan a soft copy an nei because f hole gazette hole le ka 2008 da trong chuan upload kha a boi thak le kami malam pa kha a hard copy pui kha ni ta scan not kha phal box hi lo type thak le ngai ta ni chuan state nodal officer la pu mon changa na poina chuan department sang kha akharin nodal officer aro na point mok cheu kha mo kha in ti tu chu engangi nge athu thada kha printing and stationery report ma chu thatil thi thawa te ma se proofreading array lu ga te mani concern department tho kha proofreading in lo tia chuan in upload ze kha mai ta ni chu anron monitor veringa lo hianin video conferencing hian ICT tu nang kai kol ka chia lawa enge an progress chu ka thalo ma se an la zo lo ti chu kham ka chia ka tin an zo mai ngai na kham le lo chu department sang ho ka han yen pa cheu ni I think that's all I can say, and then we'll have a better interactive system, and then if any clarification is required, we have sufficient experts here, and then I feel very assured. Thank you.
Thank you, Mr. Manlachwala. You had raised a few issues. One is about the jails you had visited in Mamit. I think I have visited almost all the jails in Mizoram. Right before the separation of judiciary was implemented here in Mizoram. Yes, the courts visit the jails. And I was specifically instructed by the Guwahati High Court to visit all the jails and also the lockups in Mizoram. It was a big task for me. We have different lockups. Yes, and these jails and lockups are not maintained by the courts. They are usually maintained by the executive. So I think the burden lies on the executive to maintain the jails, to maintain the lockups. I would like to mention one experience I had at Zokothar. Zokothar is the border town of Champhai, where there was a lockup, there was a police station. In fact, there was no police station earlier, there was no outpost earlier. After my visit to Champhai, I had visited Zokothar. I said, why don't you have an outpost, at least an outpost here? Then the next visit I went to Zokothar was when they had established an outpost there. And I said, where is your lockup? There was a pigsty, pigsty sort of enclosure He said, this is our lockup. I said, this is not done. So it is in fact the courts who visit the jails, who visit the lockups on regular basis. We have reports, we give reports to the government, we give reports to the High Court on regular basis. I would like to state in Saya, where the inmates are free to go in and out. In fact, some of the inmates go out in the mornings, come back in the evenings. This is the state of affairs in Mizoram. We are very law-abiding. Otherwise, I don't think in other states such a state of affairs would be there. And they willingly come back to the jails in the evening and spend their time there. Anyway, and another issue is about speedy justice. Yes, we admit that sometimes in various cases speedy justice is not administered. But this is not only our fault, it is also the fault of the prosecution or the executive, in fact, who do not push the cases. If cases are pushed regularly, I was posted at Lunglei for a tenure of 3 years. My colleague here over there, Puchoya, was there, he is a good gun shooter. When I left, I did not have any criminal cases which were pending over 1 year. I do not know whether it is a record, but at least for myself, for my own record, I did not have any cases that were pending over 1 year. Cases which came in were resolved within a matter of 1 year. In fact, some of the cases were just 5-6 months old. Yes, adverse judgments. Again, I am not speaking on behalf of the judiciary, but yes, adverse judgments are there. But there are always recourses for that. We have the what you call the courts, higher courts, where we can appeal, where we can review our judgments, where we can go for a review of our judgments, and there are always ways and means for those. Anyway, and last but not the least, people who approach the courts, I usually, as our resource person had said, are not those who are satisfied with the administration of justice or administration of the executive or the legislative, as the matter is. People, especially in Mizoram, are very reluctant to approach the courts. This is a last resort for us. When we feel that injustice has been done to us, that is only when we approach the courts, especially in Mizoram. Maybe criminal cases may be different, but especially in civil cases or other matters, it is as a last resort when we approach the courts. Yes, the courts, as a duty inborn to the people, have to accept those people who come to us, treat them well, treat them in a human manner, so that even before justice is done, they feel that, yes, we have come to the right place. This is the approach the judicial officers and the judiciary has to give, and the picture that has to be given to the public in general. Yes, we admit that. But as I said, we have a lot of shortcomings in the judiciary, not only from the judiciary, but inborn from the other organs of the government and society also. Now I'd like to invite questions. Few questions, not many, because I think we have another session coming up from the audience. Maybe 5, 4, 6, whatever. Short questions, which the resource person or the other dignitaries also can answer.
Executive lamina judiciary lama traban basic. Kami not for diploma. Kami superintendent land revenue settlement department. Helai loka government of general office kan dia. Masih angry petition te judgment te. Kan muahi kan in hai tere le hearing sarkar ni huwa te kan phong thina. Time limitation ko tina order back to H1 time frame on setback to sia. Respondent nante na sata ka kan press angaya. District function kan lo nito na requisition na kichina dan honorable judge na asya kha. Dan na mai ele na requisition case ni. Case dan ko tam thona. July ti ma da mo da pa na mo te ni lo ni kan problem hi lekha minna hangover ma se lai kan mo lai ta kan so ti da na ko mangena ti kha ani chu kan so na chu
So, ila kai ko bila kan. So na damo. So if there are any other questions, bring them up together.
Di ko mulai kan so tangan. Pakan na chuan di china kan resource person na akan sai. Lai ta ta kha ani ya. Ko tina case and the whole. He witnessed to Zama hearing. Man the Khan witnessed ten can hear. Kal assault no gumadu ate. Po to the charge having the tongue tira. Got them in fix up laying touch it till not the John and Tiagan Kalsena. And the avowing prosecution the unfair for opponent. Tiantanania. When the president says president and the line, Koilaya or Andam let him down, witness and no drama. Though mine Zakai not but though mine and witness, Kota and Miss Romantian and producer, Kotin and Rail Saka. The John Airline and when the president active tak alone in Tolova. Tin and who line Kota and Goa. Uncle China, Uncle not a Martin Loving. So Hera, the Laya said, Nisani and to a pot. Literally, the local level, the unlocked in a wagon. Uncle to Tolova. Jimmy Uncle Golo, the accused stand an advantage calodiness in the prosecution affair, the Trinity, and the Fogmaya. Hey, Kanfapahi, dark in Africa, June 19. Thil tu na ka soi hi atak takai kan su koi ke ma ka ta kum ma kal ta vela an thian pa kes pakhat a khan witness a tin an thian pa kha adik lo ni ti ko a ya ko ta ko a he chu adik lo lo ka chi lo ka ti mia ma yang a tia ko ta koi som chuan ko wa vai khat ma thu sai na hon nei lo in alo hong le zara zara an department a witness an ko an pu te ho man ke ni chu kan ka du to le ne ka du to big su an tia ka pa ka to lo mai do na ti e no kan in me lo he lam pa nga angai ko mo ko te si na mi ke ya a chu wang in kan in me lo kan se lo kan na me lo ka ti ka na When came here a statement and letter of chút tiếng chút tâm tất cả nhà hey executive dan yan i got kan be say na a fail khop maya elai ti la yan hey ati da man ti le chu mi lu pui tho pa khan ke ma ni sarkar na tho pui nge official te SCB ka tangin PC Act ina mo and prosecutor kunga kumru nuwa po ang case fel lawa executive kan officer na thok kan indai lo pha anin mo pole katiang song kun rei ta an tuar ko len ti ati fel ma sak te dan aom lo ni atur tu chu executive ni so kan thok case nei ren ai a case nei ren ta an lo te lo lo an na lo tu lo tin katiang he ta an promotion te an en mo alo ba na tin a department pen kan tuar ni katianga sarkar na top executive employees ho es ko tina atep up rei thei lu tu le tang a final rei thei no confirm me ati ne deu da au men ti lai ka ni le se la tin ta ma a kon soi tu a se ban tu lo ko God ruling he, God judgment he. Heavy private advocate tekal tangyan in roton na anse kuchinga. Department aron chelo. Department aron chelo apanga kan buha lo execution kan to tamito. Judgment at peju mình sửa chào tổ lâuula, just diện lâu, magistrate diện đi lâu, ukil diện rộng đi ổn tắc đi bên phố. Thế mà hiện in bị diện đi judiciary đi ngay, na sao mà nghe ô, department execution kan mula tam tak đi, judgment kan mula tam en, en vang nghe kan mula, in pechuak lâu nghe. Khá ukil thế này là phan lệ lắm mình ăn rồi ukil thế này là phan cái số cá ở đâu bờ ruộng in thì mấy à chú mình phải ta xí đầu chuyện này thế là dân ghép liền quý ở mà cái gì department tâm ta kinh execution case kan tàu phone nó anh ấy hiện tại hiện hậu thế cả à rồi nãy mà in sang mong nó mà cái lệ có mình mà sẽ rồi nãy mình lại sang mấy năm nha.
Kami juga isi baju kan dia, jangan kema jurisdiction dia kan Finance Commissioner and Secretary Kazu Kalani Nikshaka kan my respected district judge has already responded to the questions. Tuna Mamidayani, Chief Judicial Magistrate, the Senior Civil Judge in Kakamega. And in addition to what my district judge has already said, I would like to add that with the initiative taken by the Member Secretary, I think for a very long time, for almost 10 years, we've been giving reports to the state government via the district judge. And with the initiative taken by the Member Secretary, we've also submitted the reports to the IG prison. And my question to, not my question, Hello? Yeah. My question to the Finance Commissioner is that, of course, I can see that your recent visit to the jails have obviously awakened your passion for the inmates and the conditions that they're under. But we also realize that as a judiciary, the reports that we give are often, received with the financial constraints that the state is facing. So, effective takle inmates they har sadnate design height or here state financial constraint sharing chung hian intinge judiciary ko hian mali to ai chakzokin kan lak leng tikha advice kan til to a chan chu apoi mo emema kan report ani mi ya atik lo le enge mitatil lo na bo kan soiren amaro chu asyam chu chu kan my honorable district judge asui to angkhan executive ina take care to ni a to that one state in sarkar in harsan tak moisalama ania dikhania that conundrum that whole thing intinge kai pani how here as a state, I mean state responsibility ala in magan lati ang dikhai advice ka kan shachak me ni chuan to me ba ka chuan tuna khanin nge ka respond to change ka shilawa but I think the necessary thing we have to realize nge ka respond sa nge judicial officers they can judgment writing to he can straightforward but these are things that has to be relegated to the past. Mun kal to athil thingani a disciplinary proceedings bolak to ni he modern intellectual discourse yani anything to thing hanala tel reng dikha kan soivele to chon chumi ba ka chuanin enge communication chungchanga khan sarkar yani court dina yani AGA ABB te ni peka coordination ye ai han chak zo ke se communication khan chak zo ni o dikha kan soivele to chuanin speedy disposal chungchanga khanin achina khan prosecution sanction chungchanga kan han soizowa prosecution sanction it help mo takani but it also has been used for considerable amount of time in history that it has been used by the executive as a sort of blanket more to prevent the course of justice from taking its course and the prosecution sanction in the course sarkar na to kalo corrupt ni chuan corruption in the course of his work ni lo shima in prosecution sanction in the center akan zo be me do ni to kan mang tik lo executive yan the executive to ni lo ve sarkar shim yan mission yan in protect na kan mang tik lo court po hitam takyan mislead kan ni ti te po kha anong be ta kha chu dai sa chama clarification kan don tura ta thaila chumi pa ka chu
case vom lum ti hi tu ma tang kan lo he to chena amengena chona wangin magistrate ang te kan lo thok ve nok to chena tu ma district ate aum zian ya lang chu koi samanga case wati to te na kha ni ma ya amaro chu eng tak hinge aum zia chu tiang in case poi sai na avam lum thik mai mai ni ti la ya tha executive base sei na mo mi pui base sei na mo hi chu ani lo beling ka hia khatian kong kha alo lo thei reng mi poi samanga case ba chin fele mo vom lum mo pati kha kan zo ve ta.
Yeah, I'd just like to add to what Gracie had said. The system that we follow is that once an FIR is lodged, the first information is lodged and it is registered, it is added to the docket and it is taken as a pending case. Though the judiciary doesn't come in at that stage, the judiciary comes in only after investigation is complete, after the charge sheet is filed, and after charges are framed. Then only the trial starts. That's where the judiciary comes in. Prior to that, it is in the hands of the prosecution. So it would be, we have to take a realistic view regarding this delay, because prior to taking of charge, it is in the hands of the prosecution. So this is one aspect. Secondly, since the Finance Commissioner is here, court halls having modern, good standard court halls and accommodation of the judicial officers in proper quarters is very essential. Unless the judicial officers have good accommodation, befitting their stature, and court halls having good modern facilities, dispensation of justice will remain a distant idea. I had visited Tejpur in Assam about just when I became a judge. So I went there. The first building was the residence of the Deputy Commissioner. It was a palatial kind of residence. The next one was of the Superintendent of Police, another magnificent building. And the third one was a small house. I am told that this is the residence of the district judge. So this immediately I came back and reported to the High Court that there must be, this is not important. Accommodation is only one thing, but then it gives an impression that somehow there is an imbalance. So, Finance Commissioner will look into this aspect. There are genuine remarks of the judicial officers, their accommodation, and the infrastructure of the court. This is it's of primary importance. After all, a country or a community or a state is recognized by two things. One is independent judiciary, and secondly is a independent media. Without an independent media, without a free media, without an independent judiciary, a country, stature of a country or a community or a state cannot be properly measured. Thank you.
Receiving late receival of judgment orders from the High Court, now the government advocates are there to represent the state government where cases are tried. Now recently, that is this year itself, we had a meeting of all the nodal officers from all the departments and the government advocates. And the problems faced by the various departments concerning cases that were dealt with in the High Court was also discussed, High Court and the district courts. And I have a feeling this problem which was raised, pointed out, was a problem which was inexistent before. I mean, recently I don't think such a problem exists anymore because none of the nodal officers or the departments had raised this point while having an open discussion with the government advocates as to how to handle court cases in a better way. And then in those meetings or discussions that we had also distributed the mobile numbers of all the government advocates so that an easy access to the government advocates is also available to all the departments in the state government. So I do not think, I'm not sure, but I have a feeling that this problem may have been solved, and since it was not raised at the time when various problems were discussed with the government advocates. But even so, we will again remind the government advocates to make sure that all the departments received the judgments as promptly as possible. And also we will again, since all the departments are here, remind you that you can always contact the government advocates when you have a case in the court or the district court. We should also be more vigilant, and the dates which are fixed for judgment orders, etc., we can always find out because now we have the IT in place, I think, where the cost list of all the in all the courts are also available in the what do you call, I'm not a very IT person, but what is the certain term that is used in the websites? Okay, it's all CIS. Okay, in the CIS. Okay, I'm not a very in the CIS where cases can be monitored. So if the departments are interested in a certain judgments, a copy of the judgments or the dates when the matter is going to come up for hearing can be updated or checked, and we can also always contact our government advocates over the phone concerning what is the outcome of the case, and if required we can always request them to supply the judgment order as quickly as possible. So I think there's this open communication now between the government advocates and all the departments in the government.
Hello. Aho kan timai thia dam tak thil pakhat taka kan department kan ton ma kan son na ni basing kan tar an rim duwa ne kan law secretary page an rechi angin ka fia ke saka e mi pakhat department kan political lama kan foi tu ten politics lama kan foi ten ko ta min asin an roya ka duty and perform na lama kan to sura to ka physically handicap anita chumin hu chuan physically handicapped ang chuan haron di la kengi chuan kan lo pete ni chumi chu at nulama khanin khalaya ato so to chu chang khan compensation a claim ta kami kesa khan a compensation a to so to hu da ya lo lo ve tu department na kha kami a compensation claim na khan respondent number 1 ha kan li cha maya kan ti tur kha om re lo bani han mai po khan a kesa point chianga ang le kha thelu ma sa ka po amara chu ka ukil roi khan in respondent number 1 khan ka department na khami ti wang khan min ko se maya kha chu lai kho pang ai pang pon hin chu tel lo be ti mai kha kan judicial officer te ta tak be si de wani hela ya ukil na ran si tel ba na a ke sa in ro na nei re lo in ko bang si de tha chu om lo the se ukil ron si ang kal pui mo ta kha chu a fu lo de win ka re kha ti he sa ta kan sai lam pui mani chu.
I think we can wind up. One, we have another session. Delay in furnishing of judgments, copies, orders to the departments and secretary in South. Our law secretary has already responded. In fact, at one time in my tenure as the law secretary, I had tried to make designated advocates for particular departments. But probably that was too taxing upon the advocates. They did not want it, so the general pool was then again made. Now the general pool is there, we do not know who our particular designated government advocate is. A government advocate and tamta khanin tunge ni kan government advocate big di kha kan shelawa kahun lai reilote kahun lai khanin designated department pali te pathum te khanin government advocate pakhat pani te kha in chom ro se antia khatiang khachuan check and balance po kha zio no leka masengin an pe reilo niam ka law secretary nu khanin kha leha general pool ang khanin an po ni se kha khachu an soyang khanin government advocate kan neya on duty ani court duty ani to lem lo kha khachu government advocate ne na khanin copy kan pe kan furnish ani khanin a concerned department ne na pe khachu sarkar roi ani ale lama chuani sarkari an lokpo an pe ani chuani duty ani ti kha kan soiwa nia delay in cases kunga kubruk nuwa antia adik thau case chu adu rate masengin keini hena alo lu chin chu charge sheet on to nuwa case anron thelu atang hianin kota chuanin oma kami ma kha chuanin police te mo prosecution te mo ACB te kota aom chinani kami chu investigation an ti chu mi chang chuanin adu reve phianani tiang ang thau khalin PC Act sa te kan hantia eruk ani maya PC Act kan hanti chu Eru case hianin nia Eru tu te hi an lo lian ve an reng thia thina ko ta lo thlen nu hi chuanin eng mo hi alo in thak ang lam ve thia ke ni ko ta kan thlir tu chu material ani a material si lo kha chuanin ti ngai na wa lo fo thin ani ti kha kan siam chukin sia chuan case vong lum kan han ti boka a vong lum chia hi chu kala hla chiang chia lawa ke chuanin ma seng chim lam panga ka vong lai chuanin an mani ni local custom hi an lo nei ve sa kan tal tua an dia sa kan ei ho tua an dia witness hi an local tamia lo ani voi tam kan ko phok thin ani achang chuanin kan han ko ho thei lo chuanin warrant of arrest kan thia man dura tin kan han ko thina chu hunan local po chuan sa kan tal tua fil victor ni long ni an dia ke ni lam pang atang chuanin a case a material angin kan ti fel thin avong lum hi chu ka shet voi khat na ni ka kan soi duwa nia FIR te kan han soya FIR kan the lu atanga he ta charge sheet hi hun hi adu ve thin ani investigation an han tia FIR lu hianin kota alo lu kal mai lawa kota an lo lu chu an tam an mang te khatiang ang kha remand tam le na local le na deal na hi ani tlang pui china ke ni athu buai ang taka kan khoya kan han rel china chu charge sheet lo lu do no in ni investigation anti zoa charge sheet lo lu ta he chu case pui ting ani an bang ti nuwa ani ke ni ko din kan lo wai to china ni ti kha an ta lam du ani I have continued in Mizo for the benefit of the okay, yes. Resource person.
So finally it ends like the other way around. I was passing. Fun constraint on Tunga thinking and young handy to come in and Zephyr can do the Sana Katu. Namani put a prison Katu, the Katu Koshato. Amaro to kill some Tramatrama and Mamozia. So hearing Tilampanga, I mean, Tampo had in action that took down in Kaipo, all Tidas Ovania, I did to Tokatsu, and Karina, Amaro to prison, the Katu, administration, Shandia, and head for a Sham Tower, and financial head, accounting head, Poka, and Toti, the Katu, Tremela. In an inspector, report the cardinal and Falzella, action that took to the Tampo Kani, all something in a Kani. Fun constraints of Auma. Tu na hianin kalau mai tu tu lo kan do kan lai khan kan odi pakat chu judiciary chungza na fun central electoral local kami na engenga mo building an sa kan odi ti na ria Mizoram ma hianin ka tu na ka mai tu chu zo mai lo ka kan te po ka central electoral po hianin fun ti chu aum thi ni state a chuan kan resource constraint resource ini revenue kan nei lo sia ria tani ta khanin budget kan siama hey secretary law secretary tu na ta i ko kan ni boka ron te kap ve kan ni ama ro to ti ve thi ani lo state ta chuanin voi le khata thil zong zong a siam than te thei lo judiciary de po a face man na hianin plan taula tung kuma hi na kuma hi khatiang te de khan tiula all sam de voi le khata Fani dom deal tu kacuan harta alo hentilam pakai mani ta ko apa kata cuan tu state fund din na dam le chu central fund po chu tun na hian kan siam hen so ina sa project siama central electoral fund tam thiam per la state chu ni matching share ngot kan lo tu nga department tak tak hen te herin man la ni chuan judicial circuit tak ai ni om le ko shelo wa external aided fund te tin na ba ro ya te hian ni la ve thiam ti te po ha ne zamin ula chu state remote ni lo fund da po ha ngai tu thiam ngai ta ni khati la ya ka chuan e mani pon kan resource klem te kan lo ne state matching share 90 10 te lo ni ta ka between the 10 central ina to 10 the 90 central ina to 10 pe ni 10 te ka chu ala sia ta ni a via state ka chunga kanan tum ka chuan in te ni revenue nei box si lo e ga mo le ka tax santi do ni la mi khin tum oi reng mai ye ma ngok kan lo dia share thiam bi kan ngai ve ya ila ya kha ka han soi mu chu ani chu state la chuan chu han dong loi la kil tang tang hian tin ngani minister to e secretary ko te ka sabia wa ta han kan ti thei se la chu kan lo tia ma ro chu kan resource de limit kami biar panga khan central lam panga tangin mo tin chu mi na da part ho ya ko hian in ati thei na part ho po ni nga musa kan la department chang hian in kan sima an implement na sa event ni khatir chi te ti next time le da ko hian db jai ka ti bel hian ni nom em ka shelo wa khatir te po kha explore ri ta wala ngani nga tangin fun kan ti ka state hi join kan resource ti mi chi ai chu ka shel ta ka
so na kau makan thang sok do chu pakhan la chon ko ta poisa da vom tum ti kha chu criminal case fine le imprisonment ai mo zo kham shil nya poisa da case thi chan ni chu fine an choi ti ra ano tan do kha ta ti la case to na ni chu an kon ka khathum kha zero ta to ni chon khathum le chen sang ma a choi ti chon khathum kha choro tan to wa na ngai to lo chen sang an fine ti ra an case so ti na ni mai ka vom tum ti le ma fine kha sarkar chala na ru chon helai ka SAD US ti chu ko ta chon petition chon tu po party sa an del thia ma se kha case a khan liability nge ka ti don cause of action kan nei lo chuan ke ma ni party ton strike out tu din a ti thia kan di langa ko din phasa chon party ta kan tel do lo ne mai khalai khan isla chon helai ya kan DS kal pension so na kha ko ta witness ko chin tia kha witness ko hian khamini ta kha magistrate ta cha sakha thil da nga kal kha chon witness khala thelo sa ma tin a cha chon witness chen kha chu pathum ko se pakhat khan ti le ku tu ni lem ko tho ti chang alo om pal ve the ni kha chu om se cha mo ma se tu na hi chuan official ti chu ingai poi mo nia abi kin hen doctor tele expert evidence te hi chu e an na ale thun pui lo khilai le engwa po hian ko ti chuan e priority e pe to ni ala khen pal chu pal mai thea ma se kha chu om sen to lo ti ne tin da na hian sarkar ukil bi ka khan e civil case ne chu government advocate and their criminal ne chu public prosecutor kan dia dan ko inject sa chu sarkar ayo dinga ne chuan an ne na court in order le judgment serve khan serve phang mai ni ka kha chu court na ti tur chin na ti zo de kha ka se de sa ni chu.
There are no more questions. I think we can wind up this session. I think there is a break for how many minutes? Secretary? We have to. Okay, I think we can continue with the second session. We'll call upon our law registrar, B. Helen Dongliani.
Honorable Mr. Justice Ujjwal Bhuyan, Mr. Anand Swama, Commissioner and Secretary to the Government of Mizoram Finance, Madam Mardi Banku, Secretary Law Department, distinguished guests, ladies and gentlemen. Without much ado, we will we'll proceed with the second session of our seminar.
before calling upon our resource person, I would like to add just a few sentences regarding the objective of having today's seminar. Though it was already dwelt upon by the speakers as well as the our chief guest, our guest of honor, and our speakers, I would like to add that the separation is mainly for the checks and balance of the different powers within the constitutional framework, the executive, the judiciary, and the legislature. We are not different, we are working together for one common goal, that is the good governance. So for that purpose, we had a feeling that we should all assemble here together, have a discussion, and go back with at least one step of some benefits regarding the working of the different organs of the constitutional framework, where we all play a very pivotal role. So for this purpose, with that hope in our mind, we have organized this with the help of the State Legal Services Authority, and the Lordship had been kind enough to come over to our state. It is especially during the vacation of our High Court at the principal seat. He has taken out his time to spend some time with us, and I think, and I sincerely hope that this seminar would be of a benefit to all of us. I will just reply one query that was made regarding the witnesses waiting in the courts, cases being adjourned, and not having a proper reception for the witnesses. In this regard, there has been a reply from our law secretary, there has been a reply from my joint registrar also. The problems have already been explained. But in addition to that, what I would like to say is the inadequate infrastructure. Because we are housed in small court buildings where we don't have sufficient place for witnesses to wait. Sometimes there are vulnerable witnesses, sometimes we have child witnesses, sometimes we have pregnant women who can't stay in the corridors for long. For them, half an hour may also be long. But for a court procedure, it takes sometimes at least 2 or 3 hours and maybe a whole day to examine one witness. If I may just explain the procedure of taking evidence is you first do the examination in chief, that is followed by cross-examination, and if required, re-examination by the person who calls the witness. So depending on the vitality of the witness and the nature of evidence used by such persons, the time they consume for one person also takes it can take a very long time, though in some cases it can be for 10-15 minutes. So with the able officers now placed in all the districts, I do not think that despite the infrastructure, the lack of infrastructure which we have, with that will no longer be a problem. And with the support of the state government and the assurance that we have received from the state government so far with regard to our infrastructure also, I think this kind of problems will be a thing of the past. So without much ado, I will call upon Madam Marley Van Kom to deliver a speech on the role and responsibilities of the executive for the development of judiciary.
Our senior advocate and advisor to the Honorable CM, although he has left, we still addressing him. Then our Commissioner and Secretary, Finance Department, our judicial officers and officers from the state government, and all respected gathering that has come here today. Now today, the subject which I'm to talk about is, if you look at the subject matter, it is role and responsibilities of the executive for the development of the judiciary. Now the word development has been used. So it obviously shows that there is something lacking in the judiciary which has to be improved upon. Now, as already highlighted by our Honorable Judge, the system of working system of the judiciary, executive, that has all been explained. So I will not dwell into all those matters. I will just look into the aspect of development of the judiciary, which is very required. If you look at the constitution, as we have already said on and off, there are the three pillars in the government that is in India. The three pillars are the executive, the judiciary, and the legislative. So the subject matter today itself, it is for the development of the judiciary. Now when we are the three pillars, that means supposing you have these three pillars here, and what is the role of these three pillars? It is to uphold our constitution. We have a constitution, and to uphold the provisions of our constitution, it needs three pillars, which are these three. But if the three pillars are not equal, are not in the same height, it would obviously mean that our constitution is slightly lopsided. You know, it is not as it should be. It is not standing erect. It is not a straight line, but it is lopsided, and something needs to be developed. Development of the judiciary in the state of Mizoram, let's say. Okay. Now, as Honorable Chief Justice, Chief Guest had mentioned, he had gone to a particular place where buildings of three executive officers were there. But the judiciary building was found to be lacking in many aspects. That means in that place, Dejpur or whatever, we are there, these three pillars are there to uphold the constitution, but out there, is justice being delivered, okay, or is the constitution, that is the provisions of the constitution, slightly lopsided? Maybe something has to be done to uplift the judiciary so that you have the constitution as it is, should be. So these three pillars are the guardians of the constitution, and if there's anything lacking in one of the pillars, then something has to be done. Now, as per the constitution, it is the working system of these three pillars, and in the working system of these three pillars, it is found that the judiciary has to be independent, while the executive and the legislative, they are more interconnected in the performance of their duty. But for the judiciary, it has to be independent so that it is capable of giving justice freely and fairly without any outside interference. I'll just go back into that. And then it is obvious that, as we all know, the judiciary is a multi-layered system. We all know that you have the Supreme Court at the top, then the high courts and the district courts at the state level. So the Supreme Court is looked after by the central government, while the high courts and the district courts belong to the state government. They have to be looked after by the state government. It is the responsibility of the state government to ensure that justice is delivered to the people freely and fairly. The judiciary is also developed. So development of the state judiciary is purely the responsibility of the executive. So if we look into Mizoram, that is our state, okay, the state government, that is the executive, has to ensure that the judiciary in the state government is fully developed, and it is developed as it should be, in par with the executive and the legislative, to ensure that there is justice in the state. Okay? So when we say judiciary, it is nothing something, it belongs to our state. And now, when we come to Mizoram, as we all know, at present, the state is not having its own separate high court, but the Guwahati High Court, which is placed in Guwahati, is having three outlining benches. We all know which is the Aizawl bench, which was established way back or in 1990s. Okay, I don't know if how many of us have visited the High Court, that is the Aizawl bench. It was established in 1990, and I think it will be an eye-opener if some of us go and visit the High Court, which is here in Aizawl bench, and also compare it with the High Court, which is the principal seat in Guwahati. Okay, we have a new High Court building in Guwahati. When you compare those two High Courts, we'll notice that the Assam government has done its part in developing the judiciary out there. While the Aizawl bench, okay, the High Court, the Aizawl bench, it is the responsibility of the state government to ensure that it is also equally developed. Okay? Because we cannot have a lopsided system with the government if we are going to protect the constitution. Okay? Now, then concerning the district level, previously what happened was, before the separation of judiciary, the Deputy Commissioner and his assistants, in accordance with the rules for regulation of procedure of officers appointed to administer justice in the Lusai Hills, 1937, this was an act, rules and regulations which was made. Under this, the Deputy Commissioner and his assistants were to look after the administration of justice. Okay? This was during the time of the British governments, and then later, it was only when there was separation of judiciary from the executive that this system was done away with. Okay? It was a system that was followed, and Mizoram, as we all know, was lacking behind in separation of judiciary, and finally it happened, as mentioned on and off again. The final notification was in 2008 for the separation of judiciary from the executive. Now at that time there were 22 judicial officers who were then absorbed by the Mizoram Judicial Service Rules 2006, which repealed the Mizoram Service Rules 1989. Okay, this is just a brief background. Now, at that time, there were 22 judicial officers, which were absorbed in different grades, grade 1, grade 2, and grade 3. At present, now we are having 46 judicial officers in various grades. Just an overview of the position of the judiciary in Mizoram. I just mentioned these. Okay. Now, in grade 1, we have 14 numbers of judicial officers. We have 2 district and session judges. Okay. 5 additional district and session judges from grade 1. And then we have the special courts, that is prevention of corruption under the NDPS Act, then under the MACT, that is motor accident claim tribunal, then the workman compensation, then Mizoram State Legal Services Authority, then some of the officers, that is present registrar is also on deputation to the High Court, and at the same time I'm also on deputation to the state of Mizoram. Then again you have the grade 2 officers who are 16 in numbers. And one of the officers are on deputation to the Guwahati High Court as joint registrar. Now, the grade 2 officers hold the post of Chief Judicial Magistrates and Senior Civil Judge come Judicial Magistrate First Class. Okay, now at present there are 16 of them, and then you have the grade 3 where there are again 16 officers, and the other civil judges come Judicial Magistrate First Class. So altogether we have 46 judicial officers who are looking after the judiciary in Mizoram. Just an overview as the system of the judiciary. But when we look at the present scenario, we will find that again the district and session judges, the jurisdiction of the districts and session judges are again divided into 2. That is the Aizawl Judicial District and the Lunglei Judicial District. Now, the jurisdiction of the district and session judges are again according to the administrative and revenue districts. So under the Aizawl Judicial District, you have the districts of Champai District, Kolsip District, Mamit, Serchi, and right, okay, and then the Aizawl itself. Then under the Ruling Judicial District, you have the Saiha and the Longklai districts coming under the judicial districts. Now this is the brief scenario. Now after the separation of judiciary in 2008, before that the judiciary was looked after by the Deputy Commissioner, and the offices of the judicial officers were also somehow accommodated in the offices of the Deputy Commissioner. Now once separation has taken place, it is required that all the judicial officers are also given proper courtrooms and proper residential quarters. Now, it was, I think, sometime back in 2011 when our district court, that is the Aizawl District Court, was visited by some of the High Court judges. And it was found that our High Court, our district courts were lacking in many ways. It was Justice Geeta Mittal, who is now the Chief Justice of Jammu and Kashmir High Court, who had once come and visited our district court, Aizawl District Court. And she was so disappointed. It was just after the separation of judiciary, and we were just having the courtrooms that were being developed. We have these small little courtrooms in the district courts, and we were all wearing our gowns or the uniform, and we were there to receive her. She was very nice. She felt very welcome. But later she told me that when I looked at the courtrooms, I just felt like crying. The judicial officers were so excited to show me their courtrooms, but the conditions of the courtrooms were so sad that I just felt like crying. You know, that is the impression that other judges have. And when you look at the High Court here in Aizawl, I think it is one of the Chief Justice who had come and visited here, Chief Justice of the Guwahati High Court, who had mentioned that I think this is the smallest High Court in the whole of India. And they were kind of amused. Okay, so this is the situation of the courts. And the district court in Aizawl is supposed to be the best and the best equipped court in the, as compared to the other districts which are still under development. And one of the, if I mention, there was one a scholar who had said that if you want to look at the development of a state or a country, the best way to judge the development or the position of the state or the country is to look at the position of women in the state and also to look at their judicial system. If the judicial system is well developed, the opinion that can be formed is that this state is well developed. Okay? Because judiciary is one of the most important pillars in the government. So, if we look at the position now, we have the courtrooms which are under construction in all the districts. Okay, we have a lot of courtrooms which are under construction, and funds are being received from the Centrally Sponsored Scheme. But there is still a long way to go. Okay, since the Finance Commissioner had mentioned that external funds are being received, but it is coming in small tickets, in small amounts, and it is not possible actually to really develop judiciary when we look at the small amounts that you are receiving every year from the Centrally Sponsored Scheme. So realizing that we need more schemes, we have submitted projects to the 15 Finance Commission, etc. for more funds. But submission of projects to the 15 Finance Commission, there is no surety that we are going to get funds from the 15 Finance Commission. So what is actually required is for the state government to realize that if we want to have quick dispensation of justice, and if you want to have fair justice, what is required is the requirements of the judiciary, which is a responsibility of the state government, has to be one of the main priorities of the state government. Now, concerning the legislature also, when the legislature enacts an act, there is more responsibility on the executive to execute the act. And then along with that, the responsibility also falls on the judiciary to ensure that the acts are protected. And the work is again multiplied. For example, you have the prohibition of liquor, which is a legislative act which has been recently passed. Now, after the prohibition of liquor has been passed, the cases in the judicial courts have multiplied, I think, if I'm not mistaken, tenfold. Okay? And our judicial officers have to deal with such cases. Their workload has multiplied many a times. Now, the executive also need to think, what are the other requirements, extra requirements, which have to be provided to the judicial officers to deal with such cases. Okay. When the court is to perform its duty, it needs very basic structure. That is, it has to have a good courtroom. It has to have a chamber. It also needs to have adequate staff, which I think is very much lacking at the moment. Adequate staff is required. And besides that, as Lordship had mentioned, they also need proper residential quarters. When our judicial officers are posted outside Aizawl to other districts, they cannot be placed in homes that are rented, because if they are to rent houses, then they are under the obligation of the tenants, okay, or the landlords. If they are made the tenants, then they are placed under the obligation of the landlords. Under such circumstances, you cannot say that there is the independence of judiciary. And so because of this, since it is the state responsibility to ensure that the judiciary is well looked after, it is important that the state government realizes, as I'm speaking from the side of more from the executive, that it is necessary to give them their requirements, and it is not as if they are being pampered. In fact, it is that this is a basic requirement which is necessary for the administration of judiciary. In fact, the infrastructure development of the judiciary are also closely monitored by the Supreme Court, because it is found that to solve the problem of many backlog cases in the courts, what is important is the infrastructure is developed. So you have the All India Judges Association versus Union of India, where again certain directions have been given concerning the judiciary and their development. And they have been given direction, that is, the executive has been given certain directions, and the High Court has observed that the directions given should not be looked upon as an encroachment on the powers of the executive and the legislature to determine the service conditions of the judiciaries. There are directions to perform the long overdue obligations. It is the obligation of the state government to look after the judiciary, and the Supreme Court has observed that this is long overdue. So I think in the state of Mizoram also, it is long overdue that the development of judiciary, that is the infrastructure, has to be looked into. Now, recently our Finance Commissioner had gone to Mamit. He had taken the trouble to go to the prison, visit the jails there, and I want to request him that his next visit to Mamit, he could also take the trouble to visit the judicial buildings and see what is the requirement, what is the position of the judiciary. Is the state government actually doing its duty? Okay. Because if we have visitors coming from outside and they look at the infrastructure of the state government, they will find that you have a big legislative building, you have a huge secretariat out here. Then the next pillar, that is the judiciary, they will have to visit that also. They go to visit the district courts, they go to visit the high court, and their reaction will be, ouch, ouch, this is absolutely wrong. This is not how it has to be. The three pillars will have to be uniform. And maybe it's only because of the recent separation of judiciary that we are lacking, but the state government has to take steps to make sure that the judiciary catches up with the legislative and the executive so that there is the proper balance as envisaged by the Constitution. I will not take much time, though I have this huge paper, lots of paper, but since the time has already passed, I was supposed to deliver my address by 1 o'clock, but it was already 1 o'clock. So I've kind of cut short my prepared lecture and just highlighted some of the points. Then I'll just point out one more. There's a National Court Management System in the central government. And the National Court Management System has also pointed out many points where they have pointed out that the judicial system in India is in a great stress. It is stressful, the condition. This is because of the backlog of many cases. And the backlog of the many cases which are there is because of the requirement to develop the infrastructure of the judiciary. Now, recently, just before this lecture, many of us had pointed out that long pending cases in the courts, witnesses have to come again and again. Witnesses have to come again and again because we need more judicial officers. Okay? But we cannot have more judicial officers unless the infrastructure is in place. And along with the infrastructure, the judicial officer cannot work with just a building, even if the infrastructure is there and the person, the judicial officer, it also needs a proper, efficient staff to work with. Okay? So, if we are going to develop the judiciary, we have to ensure that with the appointment of any new judicial officer, infrastructure is required, development of the infrastructure, and besides that, the staffs. So unless there is an increase in the infrastructure facilities, and the increase in the infrastructure facilities has to keep up with the increase in the court cases. Okay, we are saying that court cases are multiplying. If court cases are multiplying, to ensure that there is a quick delivery of justice, we have to ensure that the infrastructure is also taken care of properly. Okay? The detail of the funds that has been received, the detail that I will not go into. If it is brought out during the question hour, we can discuss that. My only point, which I'd like to again retaliate, is that for the development of the judiciary, it is the executive who is the responsible person. Okay? If you want a good and efficient judiciary, it is the executive who has to make sure that the required provisions are given to the judiciary. Thank you.
Thank you, ma'am. That was indeed a very enlightening speech, and I hope this will certainly help in the working of the executive with the judiciary, the nature of working, and as our Lordship had pointed out about one school of thought, that sometimes some frictions also help in the development. But we do not say that there are frictions, but as I have stated earlier, our effort today is to bring up a better judiciary, a better relationship, so that we work together for the welfare of the state And as we have seen, our High Court is also coming up, but with the increase in the litigation, as Madam Marley had said, with the increase in the number of cases, the judicial officers and the constitution of courts also have to increase. For that, we need infrastructure. Unlike other officers in the executive, where maybe 1 or 2 rooms may be enough to work, but for judicial officers to function as a court, we need 1 courtroom, we need 1 chamber, we need 1 room for the personal staff, the stenographers. So at least 3 rooms for 1 judicial officer to work, and there are certain specifications for such rooms. So in that line, we are a bit different. If the executive provides us with a congenial working condition, both in our workplace as well as in the residence, I am sure that our able judicial officers will put all their efforts, utmost efforts, to the development of judiciary and in the dispensation of justice in our state. And with regard to the pending cases, unlike other states, we don't have many cases as compared to the other states, but we're all working on it to minimize the number of pendency in our respective courts. So with that, I will now open maybe 10-15 minutes for the interactive sessions. Any questions, comments, or suggestions?
Size and narcotics taxation under certain coma. Till Pohat, the Jimhan is a massage of Khania. Mase Ahu Lendi, hello, take away the first of that officer. For policy about what the district court on the district court one excise at here, the prosecution runs up one, the gun prosecuting inspector of the Ganda. Why aim was a Rokan Italian Facebook? Put out one security who omlo in country and built Siena, he put a liar and excise of one. Massa to train and the Pelonian country, he Arab to my book and Rolet Siena, he lion, made one to Zabo, when the Gandipa, he to Napoleon, he got his Gandhi, so don't be a so, the district in the Poiso district here, security and that district in the Pohan and that Alama again, security, Lama police, the security Vadil, Hasange, the Midnight and Sapula Travel, dear, didn't help her. When you go Lampang advantage down hearing and so hello experience ko ta hian cross examination an di shima hian kashian ta kha gai do to yani the other party opposite party an guilty an party mi ta khan cross examination an soya khan lo no thin ta ni khami lo no kha chuan I khami an va cross examine to soy lo ang do ta khan sian chi thina I chu cái mangi po hian ka tonga chuan ke pon ka ba correct tira atopa I han signature ten pe dong khan I hei ko tan po I ro re na decision sia ma po khan I affair just lo thei na chan so ma ko thian khami a lo report tu tur kha ahan paian aditel thilong ni dikha ka bon suggest dia
kan sang ko tanga kan resource person in Sanket by the German town and in the Cocha Hitava policy district court security ga lo dikha he po he game adi court specification is one in security guard room there strong room there and arms that to attend here in specification of Pekani. Government High Court here in revised specification for court halls and court rooms here and court buildings are kada kan atel sa fe kani chu wang chuanin kan munin ya alo zo lo awang khan security guard ka lo lo ani theya ma se court building ka te ani mo kan ma mo ni chuanin state government asia kha khanei tu ra dia chu ai zo la ko kan ne ya lung le ya ho ma ka sia so lo chuan mun da ma ko hian security guard chuan fe kani chuan security guard it's not only for the purpose of the safety of the materials which are stored in the Malkana. It's for the security of the litigants, for the officers and for the public as well. We have seen so many incidents in other courts, in other places. It is a must to have security guards in place who are round the clock on duty in all the court premises. For that, we have to write to the government. The Home Department will provide their personnel for that. And regarding cross-examination, if the court is properly staffed, it is with the staff of the court who has to write down the deposition with the dictation given by the judge manning the court. But in some places, I do admit, in some places, due to shortage of staff, some other persons also write with the dictation made by the court. But in spite of that, if there is irregularity or wrong recording of evidence, it is the duty of the advocate to make the correction, or for the witness to be more diligent in not to put the signature unless the deposition is correctly recorded. I don't think any judge would hesitate to make a correct recording, because once we hear, we know what is exactly said, and it is in a matter of few minutes that we record the deposition. The problem here is mainly because we do not, usually in the district courts, we record depositions in the English language. The witness, they speak in Mizo language, and then on the spot translation is made. So for that, I do admit there can be some error, irregularity in the translation. If you feel anything irregular attached, it is the duty to point out to the court then and there, so that before any signatures are inscribed upon such depositions, necessary corrections are made. So I think the public prosecutors, the witnesses in general, and the court, as well as the prosecuting inspectors, they also come to the district courts to prosecute the case. They should be more diligent to record that, to see that correct evidence is recorded. I will now call upon Ms. Gracie, Secretary, Mamit District Legal Services Authority. She is also the Chief Judicial Magistrate, to propose vote of thanks.
Good afternoon, everyone. In the program, relationship between the executive and the judiciary in the state, the two kan lo mangzo to na mi kan program kan han turian mitam tak responsible and oma mitam tak na tho ha tak awangin tun din mun e kan thleng the ani di kha bu de sha la kan wang chok to be a to the responsible person I would like to take this time to thank His Lordship, the Honorable Mr. Justice Mujaguyan, who is the Judge of the Guwahati High Court and the Executive Chairman of the Mizoram State Legal Services Authority and the Chairman of the High Court Legal Services Committee. This time I would like to talk a little bit about Mr. Justice Mujaguyan, because obviously I would like to mention that his distinguished nature and his particular affection for the state of Mizoram and its people, and his generosity and his enthusiasm in holding these kind of seminars that has brought this seminar, this present seminar that we're attending, also into fruition. I thank you, Your Lordship, for attending this seminar with us and for all the things that you have spoken about today that has obviously enlightened us with new facts and obviously with new theories and things that we should endeavor towards in the future. At this time, I would also like to thank Mr. Stila Ramzawa, the advisor to CM, for taking this time out to come here and attend this program with us. And I would also like to thank the respective district judges of the two judicial districts that we have in the state of Mizoram, the Aizawl Judicial District Judge, Mr. Arthana, and Lunglei Judicial District, Mr. Joel Joseph Lenga, who, despite being unable to make it here, has sent his representative to attend this seminar. And at this time, we also would like to thank the resource persons who have been appointed and who have taken the courses that we've studied today to such and enabled us in learning new things, and whose nuanced discourse in each subjects that they have imparted upon today, enabling us to learn more and to obviously inculcate that in our everyday and in our day-to-day work. And at this time, I also like to thank the chairman of the two technical sessions, the registrar of the Guwahati High Court and the district judge of Aizawl Judicial District. Their acumen and their ability to discern the pulse of the room has enabled the technical sessions to go smoothly. And last but not the least, I would like to thank all the participants in this room, my dearest colleagues in the Mizoram State Executive and the Legislature. I ask that with all the things that we have learned from today, that our understanding towards each other and our interactions in future would become more nuanced. And whatever we have learned today, I hope that the narrative that we take from this place will change, and that our views and thinkings about what the judiciary is and the role of the executive or the legislature, which we once held in the past, would be relegated to the past, and we would move forward from this seminar with positive thoughts and with positive ideas and ideals. And at this time also, I would like to thank all the staff of the Mizoram State Legal Services Authority who has enabled this program, helping, last but not the least, the Member Secretary of the Mizoram State Legal Services Authority, Mr. Vanil Emoya, who has dutifully done everything that he needs to do, and who is very, very creative, in bringing all of us together and holding these kind of seminars so that we all have a better understanding of each other. Thank you so much, and with that I would bid farewell to each one of you and invite you to have lunch with us, which will be served in the room next door. There are certificates that are supposed to be handed out, and I leave that to the chairman of the second technical session. Sorry, claiming karon ham hai de ula kabil law shithya pula hai kaming polang law ma se karon to pani a kan kasoile to to he kan conference hall nuam tak that kan ne kan taxation department ina nge thilphal taka min manti rani a tia buncha a kan seminar ni kan hol the wa yan taxation a thokte an how to tele staff te zong song chuma lu thu so ni kan certificate semi chunzo me se
Joseph Lon Moya. So sila yung certificate niya. Ubi sang liya na. Under Secretary Planning. Who are Liana, Deputy Director, DMR. Pu Vandar Shwaya, Inspector, SCB. Pu F. Nkuma, Inspector, SCB. P. Zuli, Lalpukwe Civil Judge. Pu Zhou Sanglian, DSP, SCB. Pu R. Lalgut Moy, US, RD. P. Gabi, Zhou Sangpui, PA to advisor to CM. H. Banu Saga, US, Deep in AR. Larvin Saga, Joint Secretary, Deep in AR. P. Larfi Apui, Civil Judge. P. Lalmuan Pui, Under Secretary, Vigilance. Pu Sangchua Ma, Joint Secretary, Printing and Stationery. Pu Lalbin Puya Tao, Joint Registrar, Guwahati High Court, Aizawl Bench. Pu Si Lalpan Puya, Under Secretary, Taxation. Pu R.K. Thaga, Vice President, MOP General Headquarters. Pu H. Lal Ningawa, Under Secretary, PWD. Pu Zhou Tan Moy, Kiangte, US, SAD. Pu Si Lal Muan Kima, US, Higher Technical. Partly, those who look taking more. Janet, Lal Tantuang Superintendent, Yeti. P. Lal Nguira Te, US, PAD. P. Zhou Dingtang Ifanai, US, SWD. US, SAD. PRL Guangui, EO to Engineer in Chief, EEC, and PNE. Penal Limque, US, Law Judiciary. Penal Neilimi, US, Law Judiciary. Pilihan Ningtangi Bar, US, Health and Family Welfare. Dr. London Moy, Superintendent, SWD. PC Lordin Deka, Deputy Secretary, SED. Deputy Civil Judge Scholarship. PF Laltan Sange Civil Judge Lunglei. UJH Lalvin Moya, Deputy Secretary Corporation. Ulal from Moya, US, Commerce and Industries. Ardal Sanima, Joint Secretary DPNAR. Dr. Nalmura Tao, Deputy Secretary, Health and Family Welfare. Tao. Nalmura Tao. Kati sual ka. Pusi Lal Sangwaya, Deputy Secretary, Petty Department. Ular Chazwala, Joint Director. Ular Sanima, Deputy Director, Land Revenue, Land Resources. Bạn nói xua là có lại UPT là Secretary CGM Đồng Thái. Ulal Thang Huda, Deputy Secretary Excise. Usi cho sợi tơ thì tôi usi cho rồi cho ăn thì rất là thì xuống. Vì mình có đi nó rồi trong cái Deputy Secretary của Judiciary. Vì Judi nó bình ra mi CGM đúng đấy. Vì mà đi văn công Secretary cái lần gì participation. Dấu sang điện là Deputy Secretary PWD. Ulal việc ra mà Judge Fast Track Court Policy. Pilal Zirpui Under Secretary Agriculture. Pi Melody Murhan Tuangi Under Secretary Finance. Who also CMDNA Additional Commissioner State Tax. Pilal Ingoi Under Secretary Sports and Youth Service SYS. Ulal Dingbaka Under Secretary. Ulal Ngai Moya Zokte Senior Civil Judge. P. Gracie Poitum, CGM Mami. Senior law tiek mo ngente conciliator. Rini lor siami civil judge. Kaning kuali. Bi bet si zo kan bari silo. Joint secretary. Banda Moya, additional district and session judge. Pilo and Siamin Namte, civil judge. Pete and Jungi, US, PNE. Under Secretary Fisheries. Uma Sondong Diana Superintendent. Ilan si Si Zukan Juanga Under Secretary PhD. Piso Muntare, Under Secretary Land Resources and Tourism. Si Losang Kuma, Joint Secretary, SYS, Sport and Youth Service in Guam. Si Lau Tiak Nungi, Deputy Secretary Finance. Pilar Ruati Under Secretary. P. Banramoy Under Secretary. P. K. Banarruate Deputy Secretary School Education. Pilar Rutsami CCM Champai. PC Langwan Pui. Si Langwan Puya Under Secretary Finance. Lars Wachua Superintendent. LRS. B. Banarsketa, Judicial Magistrate, ISO. Lal Venima, Deputy Director, LLE. Lal Soy Moya, Joint Director, LLE. And what all the Chuanin kan tilu kan tiso taboka puar taga kan lansikan ingay do na din